Well, hello and welcome to Court Corner. I'm Ashmit Kumar. Now, the Supreme Court has set up a 6-member expert committee headed by former Supreme Court Judge Justice Sapre in the Adani-Hindenburg case. Now, the panel comprises of veteran bankers like OP Bhatt and Kamath. It will review the regulatory mechanism in place and suggest steps to protect investors from market volatility. The court has also directed the market regulator SEBI to probe allegations made by Hindenburg Group against Adani, and also if the Adani Group flouted the 25% minimum public shareholding norms. Not only that, in fact, the Supreme Court directions go a step further and ask for a SEBI probe on matters even including related party transactions as well as securities contract law violations. These are aspects SEBI will now have to look into. Now, keep in mind that less than an hour after the court's order, Gautam Adani tweeted, and I quote here, "The Adani Group welcomes the order of the Honorable Supreme Court. It will bring finality in a time-bound manner. Truth will prevail." End of quote. Now, joining me now to take this discussion forward is with us Mr. J.N. Gupta, former Executive Director at SEBI and Managing Director at Stakeholders Empowerment Services. Also joining us are Anil Chaudhary, Partner at FinSec Law Advisors, as well as Ryan Karanjawala, Managing Partner at Karanjawala and Company. Gentlemen, thank you so much for joining us. On this discussion. Mr. Gupta, let me come to you first. We were discussing just last week as to which direction the order may head in. The Supreme Court has now made it clear that there needs to be an expert committee. It has, in fact, populated the expert committee with people of repute and is hoping that within 2 months' time, we'll begin to get more clarity on this regulatory process going forward. Your quick take on this expert committee being placed atop the market regulator, SEBI?
I would say it's a little bit a different interpretation of the order. Supreme Court has nowhere said that this committee is on the top of the SEBI. What it has said is this: SEBI probe is independent. This committee's remit is independent. This committee can ask for any information from the SEBI. It doesn't say that, and it also says that nowhere they are undermining the independent authority of SEBI. So let us say very clearly, these are the two different things. This committee remit is different, and it is very separate, because this committee cannot do the investigation which SEBI can do. This committee will be able to get the data from the SEBI and make this own interpretation. And this committee's remit is also for the policy perspective, that what policy perspective needs to be changed. So I would say my first reaction would be very simple. One, this will bring an end to the uncertainty which is going in the minds of investors, because uncertainty is the worst thing that can happen to any company or any investor in the stock market, more than the bad performance. A bad performance dies down in 1 week's time and the shares rebound. Uncertainty doesn't let you do this. That is one. The second part is this committee is consisting of people who are not only reputed and person of integrity, but they are the people who understand the business from all domains. There is a company domain also involved, investor domain involved, promoters domain involved. It involves the regulatory domain. So all possible things, and it is a judicial too. Basically, there are two judicial members of this also. So it has a company which is a very holistic committee. Third and most important thing is this, that it has said that these are the remit and they should work on this. The idea is this, that let us say that in Supreme Court, if you recall the hearing that happened first time, they are not bothered about one corporate or one instance. They are bothered about systemic issue. And their interpretation is not on Hindenburg or something. They are saying that how do you insulate Indian market or Indian investors from the impact of such reports which have not been authenticated by anybody. That is one very important point. The second, they have originally they have said that there is nothing to say that SEBI is not functioning. So I would say this will bring a little bit certainty. It will clear all the clouds, and probably it will be good for all, be it Adani, be it investor, be it regulator, be it government, or be it LIC or banks.
Sure, Mr. Gupta. Let me take that across to Mr. Karanjawala, who's also joining us, and I'll just supplement what Mr. Gupta was saying. And this I'll borrow from the order as a part of the order itself while describing the remit of the expert panel. One of the mandates of this panel is to investigate whether there has been any regulatory failure in dealing with alleged contravention of laws in relation to Adani companies. Mr. Karanjawala, let me bring you in on this. The mandate that has been given to the expert committee, the nature of the composition of this expert committee, does it meet the needs of transparency? This was, of course, the main driving factor behind Justice Chandrachud's earlier orders. Justice Chandrachud had said, look, there needs to be full transparency, there needs to be full confidence in this expert committee. Now, when you look at the fine print, at the mandate, at the composition, does that initial position stand satisfied?
It not only meets, one thing I must clarify right out upfront is that Gautam has been a client of mine. So everything I say, you keep that in the context of what I'm talking. Now, as far as the committee is concerned, it not only meets every aspect of transparency, but is one of the most carefully crafted committees that you could have made. And the reason I say it is, it deals with several aspects. It deals with the international aspect, it deals with the national aspect, it deals with the macro level problem, it deals with the micro level problem, and it addresses each and every one of them. Now, see the composition of the committee. As you know, this is, after all, a committee which will have a lot of international viewing because of the nature of how things panned out with the Hindenburg report. So first of all, on this committee itself, you find that there are three people who are internationally well known. OP Bhatt, former chairman of SBI, former chairman of the banking group of Bank Holders Association, now on the board of Tata Motors, an international company, TCS, an international company, Tata Steel, an international company. Then you have Nandan Nilekani, who's a legendary name both here and abroad. I don't need to tell you what he's done over the years. Then you have KV Kamath, who not only headed ICICI Bank, but also the BRICS Court, this thing. So first of all, this is a committee which will also satisfy the international community. Adding to that, they have very carefully chosen the two judicial members. Justice Sapre was not only judge of the High Court, but was the Chief Justice of three separate High Courts, was a judge of the Supreme Court, and recently Justice Chandrachud had appointed him to assist Unitech's Board of Management in the selling of its assets. So he also has a commercial experience. And we have Justice J.P. Devdar, who, as we all know, was also not only a judge of the Bombay High Court, but the former presiding officer of the Securities Appellate Tribunal. So here is a committee which is very carefully constituted, which will be able to, which has experts, which has experts in banking, experts in international finance, which can then buttress the judicial experience of the judges on it. So this is a committee, I think, which has been very carefully chosen, and even its remit has been carefully chosen, as you yourself read out. And the judges have also been very careful in one thing. SEBI said before it that we are already conducting an investigation. We are going into it in great detail. They set out the various, and you've seen from the order itself, they set out the various aspects into which they were conducting the investigation. They didn't stop SEBI. They said, you will continue, but you will also cooperate and give full information to the committee. The committee will in turn not only look at the relevant causal factors. Let me in fact take that across to
Mr. Chaudhary. That was the very... Right, Mr. Karanjawala. I think you preempted my next question. Mr. Chaudhary, if I may come to you, again, the point that Mr. Karanjawala was making that SEBI has not been stopped. SEBI, in fact, on the contrary, has been asked to investigate in a very pointed manner. The question I want to ask is, SEBI had assured by way of its submissions before the top court that, look, we're seized of the matter, we're looking into it, we're looking into the issues that have been raised. But despite that, the apex court has given a pointed direction that, look, there are three aspects that need to be probed. One is manipulation of share prices, related party transactions, and minimum public shareholding norms. Why was there a need felt by the apex court to make these pointed directions, Mr. Chaudhary?
I think we should look in this order in a perspective. We should not look at seen in isolation. Because the three biggest allegations in terms of the Hindenburg report was 19A, which is 25% minimum public shareholding compliance, related party transaction, and alleged stock manipulation. So three big items SEBI's Supreme Court said that SEBI should look into this specifically, but that does not mean the investigation should only look into these three things. SEBI has wide powers under the SEBI Act and should continue with the investigation at a larger scale, if at all, if there is a need required. So you have to understand this entire, the way SEBI has, what Supreme Court has done, basically it has reacted to the entire scheme of events where there are report issued in a foreign jurisdiction, which is leading to a rout in the at least one group of stocks, and which has actually spooked the market, and there were multiple petitions filed before the Supreme Court. The
Sure.
Supreme Court, in its wisdom, looking into the gravity of the situation, has constituted an expert committee with a more of a policy remit, where the remit is that you look into the overall assessment of the situation, strengthen investor awareness, strengthen the regulatory framework, and also find if there's any regulatory failure while dealing with. So I think the macro and the micro both have been covered by Supreme Court by two different committees. SEBI doing the regulatory work, and the expert committee have doing the more macro picture.
Sure. Mr. Gupta, let me get you in on this conversation. One of the aspects, of course, that the Supreme Court has also mandated the expert committee to look into is investor protection. And towards that end, very clearly describing that the remit of the expert panel will be an overall assessment of the causal factors that cause the volatility. And this is, of course, a reference to the Hindenburg report released on Jan 24th. And then subsequently, there was chaos here on Adani stock prices. The question I then want to ask is there room for further strengthening the framework that we already have for investor protection? And if yes, then where is this strengthening that is required in terms of the extent, the existing framework? Mr. Gupta.
See, any regulation or any law does not have any expiry date or destination. So it will always be possible to strengthen and improve any regulation or law. And same applies to the investor protection. Having said that, the one thing I would be saying is this: the volatility in the stock market is on the basis of million known and maybe billion unknown factors. So it would be very, very difficult for any committee or any regulator to say that this is the way I will reduce the volatility in the market. The only tools that are available in the market in a fair and free market would be that they can be the price filters and bands and all the things, margining, which all is there in India, better than, I'm again saying, I'm putting in emphasis, the market trading system in India, the risk management system in India, the margining system in India are better than anywhere else in the world. We are sitting on the top as far as trading regulations are concerned. We have got instantaneous monitoring of risk and margining system. Nowhere else in the world this is there. And that is proven by the fact that despite all the fall in the Adani shares, not a single settlement has had a problem, not a single broker has defaulted, nothing has happened. So this is the strength of the system. As far as the volatility is concerned, again the problem is that everything depends upon the capacity of the person. Now, you will see, if you had seen the reports, that why LIC did not sell, why LIC did not do this. These are the questions that are coming from people who do not understand operations of either the market or the investor like LIC. If tomorrow LIC was to react in a panic manner and sell Adani shares in a day, now what will happen, the shares would not be, they will not be able to sell the shares because there will be circuit filter at every day at the bottom, and they will not be able to sell, and they will keep on driving the share at the bottom and probably end up driving any Adani share to almost zero value and zero value for themselves. So no big investor can act in a panic because there is an impact cost. The more, say for example, if LIC was to buy 10% share tomorrow, it will skyrocket the market and they will still not be able to buy. So there is the impact cost because of the huge
But
thing.
Mr. Gupta, if I can ask you a supplementary question there. if I can ask you a supplementary question, Mr. Gupta, this was a very specific and pointed prayer that was made in one of the petitions that not just the LIC, but also public sector banks that have issued public money in the form of loans on the bank of pledged shares that are carrying quote-unquote inflated valuations and inflated share prices. That is something that the Apex Court has steered clear of. Supreme Court has not passed any direction towards a probe in that direction. You think that was required at this stage, the Supreme Court, to in fact look at these aspects as to how public funds were dispersed in the form of loans and investments?
I would say the Supreme Court judges are not people who are inexperienced and not knowledgeable. They very well know that this is a domain which they can never get into and they should not get into. That is why they have stayed clear of. How can a court frame a policy of lending or investment for a bank or for an investor? It is for the respective boards of the bank and the investment or investor or the regulators. Supreme Court can't step to the shoes of a regulator, that is RBI or SEBI, and then become a stock exchange and something. Supreme Court will never do that. The second thing is this: all those who are demanding this do not understand, and I repeat, they do not understand operations of a bank. I read in one of the petitions said that every loan of 500 crore and above should go to the committee. Now, what are you doing? Then every decision of the committee should be reviewed by another committee and then another committee. What are we talking? Are we doing business or something like this? So all these prayers were coming from...
Of course, that's on the larger issue. That's, of course, on the larger issue of banking reform. But we'll save that conversation for another day. We're running out of time. Mr. Karanjawala, let me come to you for the final word. As far as this entire saga is concerned, it has played out and is firmly imprinted on the public memory. People on the streets are talking about this issue. People on social media are commenting on the issue. And speaking of social media, there's a lot of commentary that is currently underway. I again ask you this in your capacity as once having advised Mr. Adani. They've welcomed this Supreme Court judgment, but broadly there's a lot of conversation on social media that seems to suggest that, look, this will simply put the matter under the carpet. 2 months hence, it will fall off the headlines. No one will be talking about it, essentially dismissing these orders and these directions coming in from the Apex Court. That's, of course, social media commentary. How would you respond to that?
What I said right in the beginning was that the committee that has been constituted could not have been, in my view, a better committee. You couldn't have found a better committee. You couldn't have found a more transparent committee. They are filled with people with utmost integrity who have held very, very responsible jobs. Now, there's no question of any of them being party to any kind of cover-up. So whatever will be looked into thoroughly. These are experts. Obviously, on social media, you'll always have a reaction of every kind. So forget what the social media says. Factually, I think it's a very carefully constituted committee, which will certainly do its job. And as I said earlier to you, it's a committee which will also have the goodwill of the international community, because there are at least 3 people who have high international standing. I forgot to speak about my friend Som. Som is a person who is an expert in SEBI. He specializes in that. His contribution will also be great. Both the judges have been very carefully found. Justice Sapre has the experience, as I said earlier, of being a judge of 3 high courts, a chief justice of 2, and a judge of the Supreme Court. And is also recently, as I told you, been appointed to ensure that the sale of Unitech assets are well sold. So these are people with experience. You have to trust them.
Indeed, Mr. Karanjawala, thank you so much for your insight. And with that, we're completely out of time here. I'd like to thank all of our panelists, Mr. Gupta, Mr. Karanjawala, as well as Mr. Anil Chaudhary. Thank you so much for taking out your time and sharing your insight with us on this Adani-Hindenburg saga. Of course, it continues. We'll, of course, continue to track the developments both from the SEBI as well as the expert committee. But for now, it's time now to head into a very short break. But coming up next, Supreme Court bench has quashed the existing system of government unilaterally appointing election commissioners, has ordered for the formation of a panel comprising the Prime Minister and much more. Details when we come back. Welcome back to Court Corner. Landmark verdict today coming in from the Apex Court on electoral reforms by a bench of 5 judges. Now, the Supreme Court has addressed the big question, why after so many years of independence does India not have a law on appointing election commissioners? Well, the current practice was essentially termed as arbitrary by a batch of petitions. It involves appointments by the law minister with no clearly codified or prescribed criteria. Now, the Supreme Court has directed for an independent appointment panel that will comprise of 1, the Prime Minister, 2, the Leader of Opposition, and 3, the Chief Justice of India. This would be the first time that there is an appointment to the Election Commission, an appointment panel of sorts. Now, the Supreme Court has noted in its order that the panel will remain in effect till there's a clear law on appointments passed by the Parliament, thereby passing the buck to the Parliament, the legislature. Further, the Supreme Court observed that the buck stops with the Election Commission to ensure purity of the electoral process. Supreme Court warned that a party in power will have an insatiable quest to remain in power through a servile commission. The Supreme Court also aired its grievances with the media. The Supreme Court noted that a large section of the media has become partisan and has abdicated its role and responsibilities. The Supreme Court, however, reserved the sharpest comments for the elected leaders and the polity. The Supreme Court noted that the Election Commission had to be protected from interference by the executive. The Supreme Court also stated that the founding fathers of India's constitution had left it to the Parliament to frame a law on appointments to the Election Commission, and that in failing to come out with a clear law, various political dispensations had betrayed the trust reposed in them. Interestingly, an independent panel was a suggestion that was made by several previous chief election commissioners, and now with this judgment that has been welcomed by most, but there's a keen eye on its implementation. Well, that's the second big takeaway from the top court, but that, unfortunately, is all the time that we have for as a part of this edition of Court Corner. And with that, it's a wrap on this. But stay with us. There's far more news and updates coming up right here on CNBC TV18.